In this class we want to talk about trade unions and industrial action. Industrial action occurs when a dispute between employees and employers cannot be resolved by negotiations. It's when there's a breakdown in negotiations. At that point, industrial action may be contemplated on the part of the trade union, let's say. It can only take place if there is support for the action within the trade union movement itself, within the, let's say the local trade union branch. The members are upset about a particular employer, the negotiations have broken down, so it's for the members then to take the decision as to whether they want to go on strike or not, whether they want to take some sort of industrial action, not necessarily going on strike, but it could be on strike, that's the most extreme, or it could be some other form of industrial action. They must collectively agree that the industrial action is appropriate, and they must follow legal procedures to make sure that what they're doing and what they're proposing fits within the law, because there is a legal framework within which employee relations is conducted. There are two types of industrial action. First of all, there is strike, which is a refusal to work. By and large, we don't live in a slave society, so we have got a right to withhold our labour. We have a right not to work, if we so choose. So the workers can refuse to work and thereby put pressure on the management, who have obligations to their suppliers and to the supply chain and so on. So the employers want to have it resolved as quickly as possible. They want to get work running again as quickly as possible. So the issue of the strike is a very powerful tool in the hands of the trade unions. They can bring a lot of pressure to bear on the management. But there can be action which is short of a strike, such as Worktorule. In other words, doing exactly what the management say or what the contracts say. Doing exactly, doing no more. So there is no goodwill, in a sense. Sometimes people, when they're at work, they do what's required of them, but they might also clean up after themselves, or clean up the workplace, or they might reorganize something, or help other people to do something. It's just something they do. People tend not to do just exactly what they're told. But when you have Worktorule, that's exactly what happens. And that means the management have got a big problem in trying to get the work done, because a lot of work is done out of a sense of goodwill, out of a sense of commitment on the part of the workers. It's not simply what's written in the contract. What's written in the contract may be the very basics. So Worktorule can be very hurtful to the organisation. There could be a go slow, where the workers seem to be working, but they're not working as fast or as diligently as perhaps in the past. They're getting the job done, but it's slow, and the whole system is moving slowly. Again, hurting the management. Could be an overtime ban. They refuse to work overtime. Sometimes when there's a peak demand for the product in the business, the management asks that the workers work an extra hour every night or whatever. And when relationship is good between management and workers, the workers may do that. They will get paid, perhaps get paid time and a half. They'll get their hourly rate plus 50% for the inconvenience and for their efforts in supplying the extra work. But an overtime ban takes away the flexibility, and management may experience problems in meeting deliveries, or their lead times on deliveries may stretch out, and it may damage the reputation of the business. So action short of a strike can be very destructive as well, and very hurtful to management. But the management can lock out the workers. That's a form of industrial action as well. That means work is stopped. The employer stops workers from working. They don't allow the workers onto the premises. The workers turn up to work, but they can't get in. And that's because management is in effect closing down the business or stopping the business for a period of time until the negotiations are resolved, until a solution is found. And it's bringing pressure to bear on the workers. The workers are not being paid for the time they're not working. Industrial action is protected if it is official. Action taken must follow legal procedures and be backed by a trade union. So the actions that, say, the unions take, they must be within the law. They must meet the legal requirements of taking industrial action. And they must be official. It must be a trade union based activity. It can't be just some group of workers organising it. It has to be recognised within the framework of the law. So the trade unions must follow legal procedures in order to avoid liability for encouraging employees to breach their employment contracts. If the trade unions don't follow legal procedures, they could be fined by the courts. The courts can punish the trade unions for not following legal procedures, and that could be costly and damaging to the trade unions. Official action protects employees from unfair dismissal. If it is an official action, then, and people say, workers say, go on strike, if it's done according to the law, then they can't be dismissed for not working. They can't be victimized by the management, or they can't be punished by the management, because it was an official strike, properly conducted. For industrial action to be protected by the law, the following must be met. The dispute relates to the organisation. It relates to the employers and the employees of the organisation. So disputes cannot be about something else. So, for example, if the workers were very upset about working conditions in another country and they went on strike, then that's not legal. That does not relate to the organisation or to the employers or the employees. It's something which is outside of the control, and the strike will not resolve the issue. That's to be resolved by governments in different countries and by the workers in different countries and international organisations and so on. So clearly going on strike in a company in the UK will not solve that problem. So that would not be a legal action. But there must be a secret ballot conducted by the union, and there must be a majority in favour of the industrial action. Clearly, if the majority are against it, it shouldn't go ahead. But there must be a majority in favour, and it must be conducted by the union. And there must be notice given to the employer, 7 days notice given to the employer about the intention to take industrial action. This will give the employer a chance to deal with raw material suppliers and component suppliers and distribution channels, and it'll enable the employer to try and tell everyone affected what is happening and why the company is not producing and meeting its obligations as was promised, perhaps during times of more stability. There is no protection if industrial action is unofficial. If it's not supported by a trade union, there's no supervision by a trade union, that's unofficial action and there is no protection. And the people taking the action could be prosecuted under the law. They're damaging the company and it's not official. If the action does not have the majority agreeing to it, and For example, if there's no ballot, no secret ballot, then it's not an official strike. And there shouldn't be secondary industrial action. That means that when people go on strike in one company, then workers from other companies who are not related to the dispute should not come and picket the company and stop workers who disagree with the strike from entering the premises, or stop deliveries to the business, or stop the functions of the business. So secondary picketing is not allowed. Also, if the action is in support of union labour practices, there's no protection. So the union labour practices are agreed between government and the trade unions and the employers, and are negotiated. So the roles of the trade unions, the roles of indeed the conduct of management also, these are negotiated and laid down, and the unions operate within a legal framework. So the government works out through their experience of working with the unions what is fair, what is reasonable, and will work out a code of practice. And the unions must follow that code of practice. Industrial action is only enforced if there is a secret ballot and a majority of the members have voted yes to the industrial action. That's the upshot. That's important. During the ballot process, members are asked if they want to pursue a strike or industrial action short of a strike, and action is taken on the majority vote. So they must be given a choice on the ballot. Do they want to have a strike, or do they want to have some action which falls short of a strike, perhaps Worktorule, banning overtime, or whatever it is. All employees have the right to decide if they want to take industrial action. Some workers should not be excluded. In fact, no workers should be excluded. So the employees have a right to decide, and they should be asked if they agree to the action or not. Employees who do not participate in industrial action must not be discriminated or disciplined by the union and employees who have opted for industrial action. There should be no victimization. If some people disagree strongly with industrial action, but yet, let's say, the majority still vote for it and it goes ahead, the people who did not agree, they should not be victimized or punished or abused or discriminated against by the people who took the action. They should not be abused verbally or physically. They should not be mistreated. They simply disagreed with the action. That's part of the democratic process. Some people agree, some people disagree. Employees who feel they have been disciplined have the right to complain to an industrial tribunal within 3 months. So if workers feel that the union or perhaps the other workers have disciplined them, or have been insulting or abusive or threatening or whatever, because they didn't take industrial action even though the majority wanted it, then if they feel that there is a case that they're being badly treated, they may go to an industrial tribunal within 3 months and argue the case. And if they win the case, they will have legal protection and further legal protection, and those who discriminated and were abusive towards them will have some sort of punishment. But industrial action should only be called upon if all other options have been exhausted. Industrial action is really the last course of action. Really, it's up to management and the unions to try and negotiate problems and resolve issues as they occur. There should be goodwill on both sides trying to resolve it, because it's in both sides' interest to resolve it. The workers need jobs to have an income to support their families and their lifestyles and so on. And the owners of the capital, the owners of the business, set up the business in the first place to make a profit. And there is a tension between the two. The workers want more and the management want more. But there should be goodwill between them to try and resolve this, recognizing their different requirements, but trying to bridge the gap. Industrial action is damaging for both parties and can result in loss of productivity for employers and loss of pay for the employees. So industrial action is not painless. It hurts. The employers lose productivity, they lose output, they might lose markets, their reputation in the market may be damaged, it hurts their suppliers. In fact, it's very destructive towards the business. On the other hand, the employees of the union, if they're on strike, will lose income as well. And they have bills to pay within their families. They've got bills for their accommodation, for their housing, and for their cars, and for the children, and so on. So both sides suffer. And that's why there should be goodwill on both sides to try and find solutions. Industrial action is a drastic step. Other options, such as consulting in resolving a dispute through, say, negotiations or arbitration, or getting some outside agency to look critically at both sides and make recommendations, or just simply sitting down to try and negotiate away, having a works council where there's feedback direct to management about issues and trying to deal with the issues even before they become big. But it may be that they have to resort to something like the arbitration service, ACAS. So it may be that that is the only way, and this is really for bigger issues. A lot of problems in industry might be very small issues, and it's important that the small issues are not allowed to become big. So the onus is on management and trade unions to try and resolve the issues when they're manageable. But that's all we need to look at in this session. We've talked about industrial action and some of the issues surrounding industrial action. This is mainly from the perspective of the UK. Clearly these practices may vary somewhat in other countries, but the general principles of the need for negotiations and what constitute good negotiations still remain in place. That's all I'm going to deal with here, so we're going to leave it at that and say thank you for watching.